Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney with offices in Atlanta, Dunwoody, Jonesboro, Cumming, and Woodstock, Georgia. We're here today to talk about adversary proceedings in bankruptcy. But before we get started, I just want to issue this brief disclaimer. We are a debt relief agency proudly assisting consumers in filing bankruptcy under the U.S. Bankruptcy Code. However, there is no attorney-client relationship with the viewer of this message. Unless there's a fee agreement, we'd have to meet with you individually to offer you applicable and accurate legal advice. This video is intended only for educational purposes. So today we're talking about adversary proceedings in bankruptcy. An adversary proceeding is a proceeding usually brought by a creditor, but it could be brought by a debtor, essentially to get a determination from the court, particularly as to the discharge of a debt. It could be brought for other reasons, but that's the primary reason. The code sections you're looking at are 11 U.S.C. 523 and 727. Essentially, the most common example is a creditor is going to bring an action to object to the discharge of their debt. Note off the bat, certain creditors don't even need to do this. For instance, if your ex-spouse is filing bankruptcy and owes you child support or alimony, that's going to be what's called a non-dischargeable debt by operation of law. So the creditor would not have to even bother with getting that official determination. It would really be up to the debtor in that scenario to argue it is dischargeable, and really they could only argue that in a Chapter 13, and really, only if it's a property settlement. So, even though you might have a debt that's listed in the bankruptcy and you've been noticed of the case, you might not even need to file an adversary. Let's say it's a 2011 bankruptcy filing and it's 2010 income taxes. The IRS doesn't have to do anything. The debt is not old enough to be discharged. It's non-dischargeable. Also, the majority of student loans will fall in that category. But let's assume it is a debt that could be discharged. A common example would be a credit card debt. Let's say you charge $3,000 on your credit card, 30 days before filing. There would be a presumption that debt's non-dischargeable. Now it would be incumbent upon American Express or whoever to bring an adversary proceeding, which is basically a separate lawsuit in a bankruptcy case, to determine whether this debt is dischargeable. If they'll have a deadline of 60 days after the meeting of creditors, even if theoretically they could win, the law is really in their favor. If they don't bring it, then the debt is going to be discharged, even if the debtor would theoretically lose in the adversary proceeding. They may determine it's just not worth it for us. And a lot of times a creditor will send a letter threatening to file an adversary, but they won't actually go forward. They're hoping to just settle prior to that deadline. That's an example of it being brought by a creditor. It could also be brought by a creditor. Maybe an individual brings it. They think the debtor's engaged in fraudulent conduct to incur the debt. That would be another example of an adversary proceeding. Now, where would a debtor bring an adversary proceeding? There are several instances. One is the lien strip. If you're getting rid of a mortgage, depending on your district, it will vary whether it must be done by adversary or done by motion. So if it must be done by adversary, the debtor would initiate an adversary proceeding serving the lender notice that they're trying to strip its second mortgage. Another example, the debtor might bring an adversary proceeding is something that occurs after the case is filed. Let's say the debtor is being, their car was wrongfully repossessed after the case is filed. The debtor could bring an adversary proceeding for the fact that the creditor violated the automatic stay, assuming that the stay was in place at the time. Their debtor's getting harassing letters, phone calls, even after the case is filed. That would be an automatic stay violation, and the creditor would be subject to potentially paying damages. So, that's an adversary proceeding. There are other adversary proceedings. There could be an adversary proceeding objecting to the entire discharge of the debt, meaning the debtor has destroyed evidence, like the debtor has destroyed their bank statements for the last 2 years. They won't provide them to the trustee. Debtor's not complying with court orders. Creditor could argue, the U.S. trustee could argue that the debt should be non-dischargeable the entire debt, all of their debts should be non-dischargeable, and that's going to be a permanent order. Debtor, won't get another chance to redo that. So, it's important, obviously, for the debtor, if they're, requested to turn over your bank statements from the last 6 months, that you must do that, or else you could be denied the discharge of your debt for failure to comply with the court order. So that is adversary proceeding.